Welcome, everyone, to this online learning experience. Before we begin, here are a few housekeeping items. Materials are available to download under the Supplements tab. Questions can be submitted under the Participation tab. We also invite you to take a few moments after the presentation to share your valuable feedback. The link to the survey can be found under your viewer window. And now to our feature presentation.
Hi, this is Cliff Readers, and I'm told that there's no video of me, so I can take my tie off, which is a pleasure. So we're going to talk today about colleges, whether they're obligated to give refunds, but really it's a bit more than that. And it's an interesting and detailed topic with a lot of law out there and a lot of law in different places, in the federal system and the state courts. And we'll try to at least cover this in a pretty detailed way. And it's a long history. For me, it goes back to a case that I had against Penn State University, and that's what interested me in this topic. Are colleges obligated to give refunds, or maybe more? I have to just spend a minute here making sure I'm advancing this properly. Okay. So the reason why this has come up today and why I was asked to do this program was because of a recent case in the United States Court of Appeals for the Third Circuit, Hickey versus University of Pittsburgh. By the way, after I prepared this presentation, there was another case in the Third Circuit, very similar, and I'll tell you about that so you can note it right now. I guess they told me it was too late to add it. Let me tell you that another case along the same lines is O'Keefe, O'Keefe, O'Keefe versus Lehigh University, also United States Court of Appeals to the Third Circuit. And this case was decided January 12th of 2024. His opinion also by Judge Krause, Krause. And so he's the chief judge. And and let's kind of start with O'Keefe just for a moment, since it's the latest decision. This is it involved a student who was arrested for public drunkenness in violation of Pennsylvania statute and later expelled from Lehigh University. Brandon O'Keefe sued two Lehigh University Police Department officers and the university for assault and battery, claiming they roughed him up, beat him up, and breach of contract, which is what we're going to mainly talk about today. The district court granted summary judgment to defense on all claims, and the Third Circuit affirmed. So they did not find a contract breach. That's what we're interested in O'Keefe, but of course, in Hickey, they went the other way. So it's very interesting. Same court, about a year apart, with a different result, and same chief judge. And it gave Judge Krause an opportunity to say what he did not say in Hickey, how Hickey was limited, shall we say. And essentially, there's no contract to get drunk on campus and not get in trouble for it. And there was nothing contractually obligating the court to give some kind of process that was not given. So that was a difference. And I think the contrast between these two cases, Hickey and O'Keefe, really tells us a lot about this area of the law and why we're looking at it, and the importance of a discrete contractual term or constitutional right. The courts seem to want to give a lot of leeway to colleges and universities, but within the confines of the doctrine that they have developed over the years. And the confines of that doctrine are there may be some explicit in writing that can be said to constitute a contract, or there better be something explicit in terms of a due process, as in the case of public universities, or contractual due process, which is also obviously we call the due process as not in a constitutional sense. It is perhaps in the contractual sense. Incidentally, in O'Keefe, the case of the drunken student at Lehigh, there was a dissent by Circuit Judge Freeman. So still not an absolutely clear distinction between these cases, at least to the extent that the chief felt differently about the recent case as opposed to Hickey. There was, in what's important to appreciate is that there was in O'Keefe a college type of hearing. It was a hearing panel, and there was no showing or identification by the plaintiff in O'Keefe that any step taken was fundamentally unfair, and thus provides no basis to resurrect his breach of contract claim. So while Penn State is as we'll talk about a little bit, is a state institution, so due process flows through the Fifth and ultimately the 14th Amendment, there is a form of contractual due process also, which is similar, and O'Keefe found that in O'Keefe, that standard was met. So the juxtaposition of Hickey and O'Keefe really give you an insight into what this whole area of the law is about. I hope I made that clear. And I hope that these are advancing in the right way as well. So we'll talk about contract issues. As I said earlier, whether a college has an obligation to a student is said to be generally in quasi-contract. And the issues that the cases explore are quasi-contract, estoppel, unjust enrichment, and of course, as we mentioned earlier, the constitutional issues. The courts really dive deeply into these various doctrines. Now, my interest in this area, my first encounter with colleges and universities started with Penn State, with Ross versus Penn State University, 1978, an old case, and not the oldest case on the subject either. So Mr. Ross was a graduate student in a department of ceramic engineering. He was terminated from the program, and in my view of the case, was terminated because of lifestyle issues, which were not recognized at that time by Title VII. And I scratched my head as to find whether Mr. Ross had any other kind of right apart from those rights which were not yet granted by Title VII or any other statutory protection, either state or federal, and started to look at the documents of his fellowship. And I realized that there was a contractual obligation to provide him a certain kind of, I guess you'd say, a certain kind of process. Not to mention that, of course, Penn State, being a state university, might also have implicated the due process guarantees of the Constitution. But this was a very, earlier area of the law. And there was nothing in the contract saying we could toss a student out for any reason, no reason, including that we don't like his lifestyle. That was not in the contract. So a complaint was filed pursuant to 4G United States Code Section 1983, alleging that his due process rights were violated and his liberty interest, because they dismissed him without a hearing. There was no hearing, and deprived him of his position as a graduate student. And the firing under those circumstances certainly would affect his reputation, hence the pleading of a liberty interest, something which is extremely difficult to prove or to have any court approve of. Implicated, of course, I said, were contract principles, because the state property interests are necessary for 14th Amendment protection. So those of you who might remember the early cases on this, Roth and Sinderman, go back to the U.S. Supreme Court. In order to have an interest in the 14th Amendment, one of the, or at least in this situation, in this scenario, it has to be shown to be a property interest. We see that frequently with respect to employees of government units. Big debate about whether that particular employee is a contracted for employee or whether they're an at-will employee. That becomes a big deal because in order for the 14th Amendment to apply, there has to be a state property interest as defined by state law. So that can dive into a whole different area of the law, but it is affixed, if you will, to the 14th Amendment. 14th Amendment does not apply unless there's a property interest as that is defined by state law. Okay, so at the time of this case, Ross case, the protection afforded by Title VII, as I said earlier, in Pennsylvania civil rights laws, did not protect a student getting kicked out of a program because his superiors disapproved of his lifestyle or other choices deemed impermissible. So we were on this relatively narrow track, I shouldn't say relatively, this very narrow track of having to prove a property interest. The parties submitted the case on stipulated facts concerning question of liability. And the university was very confident of its position, and the facts were relatively simple. They didn't have any compunctions to say why they kicked him out, and to claim that he had no property interest and no right to stay in this position. He had no rights, is essentially what they said. The plaintiff was a candidate, as I said earlier, for the Master of Science degree in the field of ceramic science. He accepted the offer given to him in a letter from the university. The program was accompanied by a grant which outlined the objective for 3 years. He was told that he was being terminated as a student for poor scholarship. The academic rules adopted by the university faculty senate relating to unsatisfactory scholarship were not applied or utilized in the termination, however. There is no university policy providing for hearing for a graduate student. There was none at the time. There was no university policy providing for hearing for a graduate student terminated for alleged unsatisfactory scholarship. And he was never given an opportunity for hearing. Academic rules were only applied to undergraduate students. The defense was, we don't have any rules for graduate students. That's simple. And of course, as I said to you earlier, got to show a state contractual interest, right? The termination, the court said the termination for unsatisfactory scholarship, the court found would be detrimental to the plaintiff. Graduate assistant is an important part of the education, and the policies and rules for students 1975 to 1976 were applied to Ross with respect to the termination. So the court found, I think you might say, in the words of the more current cases, an implied contract, or at the very least, the university was stopped from denying the application of rules that they utilized for, say, undergraduates. The court examined success in later life, and the court said that a graduate student who's kicked out for poor work will have difficulty finding a job or getting into another program. Graduate college education is just one avenue to professional skill, and the court looked at the relationship between the parties. The court noted that the relationship between a student and a private college is, by nature, contractual, and harked back to a 1923 case. See, I told you this wasn't the first one. Barker versus Bryn Mawr, which is cited, is an old Pennsylvania Supreme Court case, 278 PA 121, 122 Atlantic 220, 1923. And the court relied heavily on this. This established for the court a contractual basis. Students had been permitted to bring contract actions against institutions of higher learning for alleged breaches of their contracts. So that was very important. In whatever state you practice in, what you're going to want to do if you have these kind of cases, you're looking for the creation of a contract or the assertion of a contract, is look at state law, particularly old state law. Strank versus Mercy Hospital of Johnstown was another case that the court looked at, said that public institutions are bound to the same approach. Now, then we have the question, and the court examined the question of the reasonable expectation of the student. And this, as we know, helps to create a contractual relationship. A student has a reasonable expectation based on statement of policy by Penn State and experience of former students that if he performs required work, he will receive a degree. Ross was a graduate, that stands to reason, right? Ross was a graduate student who had a property interest in a continuation of his course of study and had no interest in any specific procedures. Okay, so you probably see where the court is going on this. You may have an interest in maintaining your scholarship with the university, but I said earlier, recall we talked earlier, what about due process? Is that somehow contractually required? And that's where the court was going after having found this this property interest in terms of the practices that were previously applied. The court then said, well, what about, is there some sort of contractual right to due process? We're not yet at the constitutional component of that. So the court noted, as we know, that due process requires a notice and an opportunity for a hearing, and due process does not require any specific procedure. I tried a lot of due process cases earlier in my career, but what's happened as the Supreme Court and the circuit courts have been an opportunity to look at those, that due process has become more and more watered down. So there isn't much that has to be given in the way of due process, unfortunately. I think that's a mistake. And I remember when the All Education Act was passed, one of the senior partners in the law firm I was in assigned me the job of going around to 22 different school districts to set up due process hearings so that students couldn't be thrown out of school without due process after that act was passed. And it's interesting going to these schools, they were totally on board with the idea that, yeah, it's fair that people be given some kind of hearing before they're disciplined or thrown out of high school. And I found greater acceptance from the administrators actually than from the courts. The courts said, well, due process really isn't much. Let's give them a reason. But we set up the administrators of these 22 different school districts that the senior partner represented were on board with the fact that there not only should be some reasons given, but an opportunity to be heard. And somebody was relatively neutral. Now, they were not about to go hire outside judges. They didn't have to, but they were interested. They were willing to accept my admonition that even if it was people from the school district, that it'd be people who were not involved in whatever the dispute was. So the due process gradually came into being as something that was a legitimate part of education, even on the level of school districts. Factors. Supreme Court, in a variety of cases, has ruled the following requirements should be evaluated when determining what's a fair hearing. Private interest of an individual affected by the official action, the risk of an erroneous deprivation of the interest with respect to the procedures used and probable safeguard, suggested the government's interest, including the government function involved and the burdens in providing the procedural requirements. So the private interest, the risk of an erroneous deprivation, and the government interest. Those are the three factors you'll see in this case. As to the decision makers, the courts have said that this is not an administrative decision based on mathematical criteria alone. The court in Ross said that a hearing would allow Ross to explain the reasons for scholarship, and the administrative burden would be minimal. The interests, what are the interests? Is there a loss of property interest in the continuation of his job as a graduate student? Asked the court. Ross's contention that he had a property interest pursuant to state law in his position as a graduate student, which necessitated protections of due process before he could be terminated, would be denied. The court just did not see that. The court did not see that it was something about state law that imported in that property interest the right to a hearing. There were due process guarantees. There were due process guarantees of an opportunity to be heard, but not maintain the graduate position. So the court made this very fine distinction that he didn't have an automatic right to that position, but he had a right to be heard on his dismissal. The court said there was no liberty interest in his reputation, honor, and integrity, which is kind of strange given that the court had earlier said, and all courts say, how important education is, particularly post high school education, graduate school education. But when it comes to really evaluating the liberty interest, not so much. The determination, said the trial court in Ross, was not made public. The defendant's decision that Ross was a poor student did not constitute an injury to reputation, which I don't know how that could not be, but I think basically what the court was saying is, well, there's no liberty interest because they didn't broadcast this. He was a bad student, allegedly. When in looking at the contract breach, the court found that Ross's claim that he needed a hearing because he had a property interest under state contract law was correct. However, that did not mean that he could not be terminated at all. In other words, it didn't give him an interest in it was not like, he had, as a result of being a graduate student, that he had tenure. It wasn't like he had tenure, that he had a job with a term. What it meant was that he was entitled to a hearing, a right to be heard, but not, I think, any particular result. So as I said earlier, it's a weak guarantee, but it's a guarantee. The interesting thing that we should just touch on is how these cases actually tried. When you get to the hearing, suppose they make up stuff. Do we get back into a constitutional or contract issue? And so that's an interesting question that most courts say if there's going to be a hearing, it has to be a hearing that has a semblance of fairness. So we started off talking about Hickey versus University of Pittsburgh, and then got into the origin, the etiology of that, if you will. So the case law, I thought it'd be interesting to compare this 1978 case that I handled to what's happening in 2023 and now 2024, of course. So the case law has transitioned away from the constitutional basis of due process to the contract basis. Courts are nervous about today, I think, about being accused of making up constitutional remedies, which are not easily findable, shall we say, in the text of the Constitution itself. So if there's other ways of looking at it, they're going to do that. Is there really much difference between constitutional due process versus contract? Since in order to have due process, there must be a property interest. So either way, there's got to be, if you're going to give somebody a contractual basis, well, there's got to be a contract, right? Call that a property interest. And if there's going to be due process, it has to be a property interest. Can due process be a matter of contract even in a non-state related institution? And the answer is clearly yes. You can give in a contract anything you want to give, any kind of agreement you want. Call it due process or not call it due process, that really depends on the case. Given funding considerations, and this is another area that is really beginning to be thought about now as a result of Title VI and Title 11, I believe, as a result of protections in connection with other rights, including religious rights, when colleges and universities receive heavy funding from the federal government, even if they are not state universities. So that raises, and hasn't really, it's a little bit beyond what we're doing here, but it's worth thinking about, that as we're evolving in terms of protection of students who assert, for example, their religious rights or other federally protected rights, what happens when private universities receiving as much money as they do from the feds, and not to mention, deductible gifts and other benefits from the IRS, to what extent are they subject to federal laws, federal anti-discrimination laws? And the fact is that they are. You'll see some colleges advertising, we don't take a penny from the federal government. Well, people who give to those colleges may very well get tax deductions. So I'm not sure there's any college or university that does not benefit somehow from the federal government, and therefore their students are going to have rights. Typically, those cases, again, a little bit off, but just mention this anyway. Typically, those cases are filed before the Department of Education, and they have their own specialized group, civil rights branch, which in my experience does nothing. Doesn't sometimes forgets about the filings altogether. We'll see what happens as time progresses. Remote learning. So remote learning, of course, this is all transitions into remote learning, which in a sense is why we're here. Learning remotely, I would mention. And Hickey versus University of Pittsburgh, University of Pittsburgh and Temple, they were both involved, transitioned to remote learning in March of 2020. The wisdom of remote learning. Well, I heard a lot about this because our office, like many of you, we also went remote. And then we went quasi-remote. We went out, we bought everybody a laptop. We had a robust enough system that everybody was able to have VPN and other ways of accessing the server. And some people liked it and some people hated it. We then, like many colleges and universities, harder for a college to do this, went to one person in an office. Luckily, we have a big enough office building. We were able to do that. People were not allowed to leave their offices. And it was a time that was of great stress. And everybody was struggling with, what do you do about this, from a financial perspective? And universities and colleges face the same thing. And in this particular case, the plaintiff lawyers, I think any lawyers who have handled these cases, are wise not to question the value of remote learning. Although there's been lots of studies on it, does not seem to work as well. But, it's generally not questioned in these cases. So the students sought in Hickey partial refund of tuition and fees on the grounds that they received an entirely different educational experience and they were promised and had been denied access to campus facilities and services for which they paid specific fees. So I thought it was very good about this. I think very. I say good. I don't not make a value judgment. I mean, in terms of how the case was presented to the court, what was good is that a distinction was made between the type of educational experience, not necessarily saying one was better than another. And I think that was an approach that was very beneficial to the plaintiffs. State law applied, said the circuit court, and ordinary contract principles were not jettisoned. Rejected was the argument that state law was displaced with a particularized body of law in the student and university context. Now, that probably is the most important thing that I can say about any of these cases, because in virtually all of them, going back to 1923, and before, maybe there were cases before that, the argument was always made, and is actually still made when you read these cases, that, well, there's something different about the college and university environment. It's different. It should be treated differently. It's a different kind of law. And it's a particularized body of law. And so the cases usually do not say that is a rejected doctrine. Some of them even embrace it, but they don't seem to follow it necessarily. Judge Muir in 1978 essentially said the same thing in Ross, although not using the same language. He scratched his judicial head and said, well, now why would I give some sort of special immunity if this is a contract? Is it a contract? And I think that presented in that way, it is more difficult for the courts to say there's a particularized body of law which insulates the institution. Quid pro quo. The question in Hickey was whether there was an implied contract to provide education and services in exchange for one tuition and two mandatory fees. They really tried to boil it down. Reservation of rights. It is understood that university programs and directions may change. I mean, that is, I guess, assumed. I'm not sure it'd be assumed in any other kind of contract, but it was assumed here. This was made explicit in the reservation of rights provisions, which was in the contract with the students, and is, these days is in every contract. Anticipating emergencies. Students need to anticipate emergency adjustments and inconveniences in campus life. Again, a statement that you won't find in general contract principles. I do serve on a Supreme Court, Pennsylvania Supreme Court Standard Jury Instruction Committee. And when it came down to coming up with instructions for contracts, a very auspicious and distinct group of judges and others who serve on this committee felt it was necessary to hire a contracts professor to help them understand contracts. So it could be very complex field of law, obviously, but in particular, the doctrine that we're not going to treat colleges and universities different than any other contractual situation is said, but then you also can see the various vagaries that are introduced that you would not see in other contracts. I've never seen a contract that says the people contracting need to anticipate emergency adjustments and inconveniences. Maybe that's somehow implied. I can't remember ever seeing it. Contractual relief. Act of deceit changes student life would not normally provide contractual relief. The court giving every reason why, no, we're not going to help these students out. Pennsylvania courts recognize a student may bring a breach of contract claim for specific undertakings that universities promise and fail to deliver, such as curriculum, accreditation, or degree. Again, going back to the older cases, the courts were not quite so specific as to look for specific promises. As in Ross, where the court found an overall implied, it was almost an implied requirement of fairness. Implied contract. In expulsion cases, as we've seen a little bit about previously, students have a reasonable expectation based on statements of policy and experience of former students, all quotes, that they will receive a degree if they perform satisfactorily and meet financial commitments. That in language, you'll remember, very similar to what you saw in the 1978 Ross versus Penn State opinion. So they have a reasonable expectation. We do not use so much anymore the concept of a property interest, rather a reasonable expectation, which is more in keeping, I think, with the way the law is currently stated. Reasonable expectation based on something, some statement of policy, something in writing, experience of former students. So a contract sort of pops into being, so to speak. Now, before we go to McCabe versus University, one of the cases cited, I'm obligated at 12:30 to give the program code and to read it twice for New York. As a fellow New Yorker, my first date of admission, I feel sorry for you. No, it's a great place. But it is one of the states where I'm admitted. So your program code is C as in Clifford, R as in Reader, CR 3440-13024. That's CR 3440-13024. So you need to get that code to get credit from the West through the West Education Center. So even though most of us say it twice, third time is a charm. CR 3440-13024. So we'll talk about McCabe versus Marywood University, which is a Pennsylvania Supreme Court case. I'm only talking about Pennsylvania cases in particular because there is a history in Pennsylvania, which I did not find as much of a history in other states, although I think these cases are consistent with what you would find in other states, New York, D.C., where I'm also admitted in some other states. So Marywood breached an implied promise set forth on its website and publication to provide a fully accredited nursing program before affirming dismissal because Marywood was fully accredited at all times. So I have run into this more in the professional degree programs where, and I had an interesting case against Bucknell a number of years ago in a teacher's program. And the question is, these programs that require accreditation by state agencies, oftentimes, they're requiring these, and they're making promises, typically implied or direct, that you take this program, you'll be able to get accredited if you successfully pass whatever testing is involved. Those cases, I think, are I hate to use the word easier cases. Nothing is easy in this field of law, but more understandable, shall we say, to the court and those who hear these cases. The student complaints in Hickey supported and applied fair contact. What university publications touted as a campus experience, and they did use that terminology. The long-standing pre-pandemic tradition of an in-person education has existed since the university system was founded in Europe. There's a separate marketing and pricing of online versus in-person programs prior to the pandemic. I think that was a very important fact because it showed that the university and the colleges themselves recognize the distinction, right? The Third Circuit, I think, somewhat concerned about opening the proverbial floodgates, was careful to point out that it's narrow. And I think you can get that out of the principles we talked about previously, where the court said, well, things change, we're aware of that, bad things happen to good people, blah, blah, blah. And so the court and Judge Krause in particular, wanted to be careful to keep this fairly narrow so that universities and colleges don't get sued for, I don't know, not providing good beer or, whatever. Okay. Damages. So the students found the court, and the court found in Krause, adequately pled damages. The students did not receive opportunity for and this is a quote from what the students were promised. They did not receive, quote, opportunity for collaborative learning and in-person dialogue, feedback, and critique for which they paid, close quote. So they were supposed to receive, the university said, we're going to give you collaborative learning and in-person dialogue. I don't know why it can't be collaborative on Zoom, for example, or web or any of these other websites like we're using here. These things can be collaborative, but collaborative, I think the court found, is kind of a term of art. And of course, in-person dialogue. In-person dialogue can only be face-to-face, right? Schools and others solicited to the public need to be careful about what they puff about, said the school. Said the court. Which is interesting because, we got lots of cases out there, as all of you folks know, do contracts work, where the courts find no contract. Oh, this is puffery, mere puffery. And look at lawyer ads. Often I watch these lawyer ads, I also chuckle about that. And boy, if that isn't puffery, I don't know of anybody being sued because they said in an ad, we're the best. We can give you the best. We'll get you the most money. I don't know. Is that a contractual promise? So, express contract only applies only where the contract is entirely unrelated to the express contract. A partial refund might be in order in those situations. Where the conduct is entirely unrelated to the express contract, a partial might be in order. The court then had a nice law school discussion about the difference between implied versus express contract, noting just because there's an express contract does not mean that there could never be an implied one. Implied contract would have some duties different from a formal contract. The de minimis conceptual overlap exists between an express contract and implied contract, but such de minimis overlap is not enough of the former to preclude the latter. So this court did not feel like there was enough of a difference between an implied contract and express contract for the express contract to cancel out an implied one. So you can have, and again, I think you need to look at your state court on that because different state courts go different ways on that. There are many state court decisions, including in Pennsylvania, that said when you've got an express contract, that does the job. Unless there's some latent ambiguity, we're not going to let any other language control. So this language is interesting, whether it's applies to state law, even in Pennsylvania or other states, is an interesting and debatable topic. The fact that express contracts discuss tuition and fee obligations in the ordinary registration does not preclude the students either from asserting a breach of implied contract based on an alleged university obligation to provide in-person courses and services in the form of a partial tuition and or refund. So the court here is willing to accept implied conditions to an express agreement. Again, I think that's, and I think one of the reasons why this court wanted to keep its holding narrow is because it realized that may not be universally accepted by the state courts and may not be universally accepted by Corbin and others who write about contracts that are cited throughout this country. Integration clause. Pittsburgh argued that it had an integration clause indicating that the express contract constitutes the entire agreement between the parties, something I've just mentioned a few moments to you. The court said this does not preclude the implied contract claim. So in that sense, we're opening up the door a bit to agreements beyond the express contract, at least in this context. What is an implied contract? An implied contract is an actual contract which arises when the parties agree upon obligations to be incurred, but their intention, instead of expressing in words, is inferred in the acts and surrounding circumstances. But what's really key here is a willingness to recognize both form of contracts between the same. Universities contend that the law has displaced the general rule with a particularized body of law in the student university context. The Third Circuit was not convinced that such special law created, that there was any special law created. We talked about that earlier. And I think the university did make the attempt to say you can't have implied when you have express, and the court, and I think where this case really went down the tubes for them is when the court was willing to reject that. What kind of cases can be brought under this doctrine? Well, specific undertakings the university promised but failed to deliver, such as certain curriculum, accreditation, or degree. This comes back to my earlier point about programs intended to permit people to be accredited by state or federal agencies. Students cited several university publications replete to references to in-person on-campus instruction and the campus experience. They had that very specific language. The court was impressed by that. The university, as we said earlier, touted or puffed the on-campus experience. The complaint in this case alleged university's tradition of in-person education. Students point out that online education is a separate product and distinct from the in-person education to be offered at a lower cost. Now, you know why they need to make that distinction, because you had an express contract. And to deal with that, they needed to talk about something different than what was ordinarily promised by the various undertakings and representations of the university that that was something different than the contract. So you did have, in effect, they're arguing here, and I think it really comes down to this, although nobody says it, two different kinds of contracts. You have the express contract for the on-campus experience, because that's what the brochures and the holdings out, that's what they're talking about. And for this novel new kind of relationship that we're now going to, you have an implied contract. So it's almost as though, the court of course never says this, that university colleges broke their promise to provide in-person experience, entered into a new kind of contract, which is not in writing, therefore is express. So that's another way of looking at this case. It's just my 2 cents about it. Student fees and the opinion listed the cost of attendance, but it's gone up a lot since then. Tuition and fees, room and board, and they actually went through each one of these. And I'm not going to do that with you here today to try to cover some other things. But the court found that factual development was required to ascertain the scope of each fee, what services were terminated, and for how long. Kind of goes to my point that that the court recognized a different kind of relationship than the express contract for in-person learning. Adequate pleading, very well pled case. My hat's off to the lawyers who wrote this complaint. Students adequately pled, I think they well pled that they had an implied contract in exchange for in-person education, said the court, but not as to Pittsburgh's house and dining fees. Fees that could not be sued for were specifically designated as non-refundable. So again, you have this mixture, this odd kind of mixture of an express versus an implied contract. I thought the court spent a lot of time talking about unjust enrichment. It consists of a plaintiff concerted benefit of the defendant. By the way, I didn't make up these cartoons. I just want you to know that I have no responsibility for them. But unjust enrichment consists of plaintiff conferred benefit on the defendant received that benefit, defendant retained the benefit under circumstances where it would be inequitable to do so without payment of value. Sounds like law school, right? Right from law school. Quarterman, whoever you had when you went to law school. That's what unjust enrichment is. The student's allegations were sufficient to survive emotional distress. The student's asserted damages are cognizable, they adequately pled damages. The type of education they bargained for, the express contract one, was not given. And both the Third Circuit and D.C. Circuit, the other place of admittance, held that the allegations of proven would rise to cognizable damages. Now, I thought it was worthwhile, the time we do have some time, to look at some other cases, because these cases do, while Hickey is fascinating to the extent that it really attempts a deep dive into the law on the subject, and it's certainly worth looking at some other cases that seem to me to be important. We also covered some other jurisdictions. So, Swartley versus Hoffner is a Pennsylvania Superior Court, that's the Intermediate Appellate Court in Pennsylvania in 1999. This was an interesting case. A college student they're all interesting, right? College student brought a case against Lehigh University and 3 committee members who voted against her dissertation. Graduate student argued that the university breached her contract to educate her, and that the university or its personnel acted in an arbitrary or capricious manner. Well, this goes back to the principle of, can you sue? You remember some people got some publicity a few years ago this is more than a few years ago, suing for educational malpractice. So that's kind of what this sounds like, right? The dissertation committee on numerous occasions found that the graduate student did not meet the qualifications, was inadequate in her thesis and her research. The graduate student then became pregnant and came back to school with a new committee being formed, which denied her degree. Educational malpractice, there it is. How did I know that? I wrote this. There's no general cause of action for educational malpractice, the court said. There's no policy against permitting a cause of action for breach of contract or misrepresentation, where, for example, a private trade school makes a representation that a certain curriculum would be offered. Sometimes what they usually say, like the Bucknell case I mentioned earlier, that, oh, by the way, this will be sufficient for you to get certified as blah, blah, whatever it is. But no malpractice. Blem versus University of Pennsylvania, this is a veterinary case. Those are not my cats or dogs. The court opened the door to a breach of contract against a private institution when it was noted that, again, the relationship was contractual. Therefore, students being disciplined are entitled only to procedural safeguards as the school specifically provides. Now, keep in mind, this is a private institution, and it's as a contractual matter, not due process under the 14th Amendment. Incidentally, lots of private entities give a lot more due process than one would get under the federal system. Swartley versus Hoffman, we talked about earlier. And we've talked about Swartley versus Hoffman earlier. And so I'm not going to go through that again. But basically, there is no general obligation to provide education in a quality manner or apparently in any manner. But as prior case notes, there is a specific cause of action for breach of contract. So we come back to the principle that they don't have to give you a very good education. But the interesting part of this from a contractual point of view is that they do promise you're going to be able to be accredited as a result of this education. Case law around the country. I promised you we'd look at other places too. There's all kinds of interesting case law on the subject from Alabama, Idaho, Ohio, all cited for the proposition that general obligations provide a good or proper education will not support a cause of education. Puffing, like the lawyer who says, I'm going to give you the best job. Everybody else are idiots. I'm the best. That puffing is puffing. However, a specific statute, or I think that should be, or regulation on contractual provisions will support a cause of action. Plaintiff's complaints which amount to general allegations of a lack of quality education, not going to do the job. Again, puffing. We'll look at Gotti versus University of Pittsburgh, 2014 case. This was yes, I did pick out this particular picture because everybody remembers this Little Shop of Horrors. So the Superior Court vacated from the court orders granting a preliminary injunction prohibiting the University of Pittsburgh dental school from dismissing Gotti. The dental school dismissed this person to the School of Medicine, as was outlined they could do in the handbook for unprofessional conduct in connection with performing a root canal. The issue involves conformed consent. So we talked earlier, the general rule, just to reiterate, students have a constitutionally protected property right in their continued employment. We know that. We talked about that earlier. A student is subject to performance of scholastic and disciplinary requirements and must perform in a satisfactory manner, citing Ross versus Penn State. Ross has been cited for that numerous times, and was in Gotti. In Gotti, the student handbook permitted dismissal for unprofessional conduct, not necessarily in performing root canals, which to me is always unprofessional, but the students repeated, no, I'm just kidding, doctor, any dentist out there, I'm just joking. The student's repeated dishonesty in his meeting with a supervisor violated the written policy in his student handbook. Assuming a binding contract existed between the student and the university, it compromises written policies and procedures in that handbook. That's what the contract consists of. Earlier about McCabe versus Marywood, as you will recall, which involved, by the way, claims other than contract. Somebody cleverly thought of unfair trade practices and consumer protection law, which is fairly standard type of statute in many, many different states. And they raised these other issues, unjust enrichment, promissory estoppel. And this was the case of the nursing student who said the college had not provided her with a fully accredited nursing program, make false representations. Cave, in that case, never averred that Marywood's conditional or temporary revoked accreditation status prevented her from graduating from a fully accredited nursing program or sitting for her licensure exam. She thought she had this tiger by the tail, because it was a temporary revocation of Marywood's status. But it's almost like, she felt to mitigate. It was almost what the court was saying. Our lawsuit is premised on speculation as to what would have happened if Marywood had lost its nursing school accreditation, which did not. The record supported the trial court's finding that McCabe's harm came from her decision to transfer schools. She did not allege that Marywood denied her opportunity to graduate from a fully accredited nursing program, so she still had that opportunity. Marywood pointed out that the nursing program was accredited in all times She could have graduated from a fully accredited program. It was just kind of a temporary glitch. We talked about other contract causes of action, and in referring to that, such as due process, where you have that kind of thing. We have a state university. What I did not mention earlier, and probably should, I'm involved in some of these cases now, is First Amendment consideration. Teaching is speech, interestingly enough. So this is a big deal on campuses today. Whether when there are professors and students who claim that their First Amendment rights, assuming again we're dealing with a public university or a private one that adopts these principles, could be violating somebody's religious rights to the extent that the university, for example, is not willing to enforce rules, regulations, policies, preventing other students or professors from speaking in favor of genocide, speaking in favor of Hamas, might be speaking in genocide, certainly to me, is advocating genocide. Does that violate the rights of other professors, teaching assistants, students who are Jewish or otherwise oppose genocide? Christians who oppose genocide of Christians in the Middle East or North Africa. So there's a whole interesting field there that is beginning to percolate about how the First Amendment, either from a contractual basis where it's endorsed, and it is in most universities, or in the context of a public university, how those rights intersect. There are rights on the First Amendment to speak, but it is also within the First Amendment a right to protection to the extent that there's violation of religious liberties. So I'm giving a talk at Georgetown on the 31st on the intersection. Maybe I should say the collision at the intersection, but the intersection of those rights. So that is a field that is beginning to boil up, and I think you'll see decisions coming out in the future. So just a sort of an honorable mention. First Amendment establishes a zone of protection for the educational process itself, which in proper circumstances must include not only students and teachers, but their host institutions as well. So that's a 1925 United States Supreme Court decision. So that sounds like an immunity from the teaching end, but how broad is that immunity, and can it infringe the rights of others? Well, we don't know that yet, and we'll be, stay tuned for that one. I mentioned earlier Title IX and Title VI of the Civil Rights Act. As you know, that clearly protects people on the basis of gender, among other things, and there are other provisions for other protections. As I said, this has recently been invoked by Jewish students as well as African American students to prevent discrimination in the school setting. The case of Kassenbaum versus a fellow of Harvard College. Interesting 70 or 80 page complaint worth taking a look at. Other cases deal with constructive discharge. One of the interesting ones is a New York case, district court case, Galley versus Columbia University. Address whether a cause of action exists for constructive discharge from a graduate school program, another dental program. Somehow dentists have these problems. Maybe it's a root canal issue. Motion for failure to state a claim is granted because the court would not create a cause of action for constructive discharge, and hence the federal court had no jurisdiction in that case. Columbia failed to address the allegations of cheating, and in fact acquiesced in the cheating at the dental school, it was claimed. They failed to correct abusive and discriminatory treatment allegedly endured from a particular doctor. They failed allegedly to properly inform the plaintiff after a second year that she had failed a course of a professor she didn't get along with. They failed promptly, it was alleged, to provide remedial services, and they failed promptly, it is alleged, to process plaintiff's tuition rebate after she took a medical leave of absence. The court recited the often heard mantra that there's no such thing as educational malpractice claims. Conceivably, any student who fails to complete a course could bring an action, and administrators do not need to conform the curriculum or curtail faculty behavior so that individual students are not offended. So that was I'm not sure that court, under the facts of this case, that was 1998, would actually go that way today. But they create a pretty bright line rule that district court did anyway. Seventh Circuit, Gussman versus Loyola. This is a Seventh Circuit 2022 decision. Loyola suspended in-person instruction because of COVID-19. The district court granted Loyola's motion to dismiss, and the students appealed. The court affirmed and vacated the students' allegations were sufficient to state a claim for contract breach. Players were permitted to amend their complaint on unjust enrichment allegations. With the existence of a contract between the parties is undisputed. An unjust enrichment claim will seldom survive a motion to dismiss, as students adequately pled unjust enrichment. So, as in the alternative. So, COVID seems to be handled a little bit differently than some of these other cases that we've looked at. And the reason for that may be that COVID was declared an emergency, a national emergency, a state emergency, and because it did, schools were trying to keep going, and they wanted to obviously keep their cash coming in. So they were reluctant to do anything in particular to give the students a financial break when they changed the way the education was provided. So I think that we may find, fast forwarding way into the future, that COVID may appear on the future radar screen as a little bit more or of a smaller blip than it seems today. That's just my thoughts about that. Or it may announce a new doctrine that the court will look at implied agreements outside the express agreement, where it constitutes unjust enrichment for the university not to give the students a break. We'll see, right? Elements of unjust enrichment are set forth, and you've seen those. We covered those previously. Another interesting case, another COVID case, is Hernandez versus Illinois Institute of Technology, based upon Gussman versus Loyola, alleged enough to go forward. Illinois, among other states, does not recognize a claim for educational malpractice. However, they said it all the time. No educational malpractice, but what Hernandez did not ask the court to rule that online education received was inadequate. Hernandez claimed did not require the court to evaluate the university's academic or educational judgment. What was alleged that he received something different that he paid for. So that was, of course, mentioned in all these cases where the plaintiff was successful, including the Third Circuit cases, that you got a different product. You don't have to say it wasn't as good. You go in to buy your Toyota, RAV, and you get a cheaper car. Toyota, they make a cheaper thing than a RAV, a Cross something or other, Crosstrek, right? What you paid for the RAV. They both may be great cars, but you're getting something different than you bargained for, even though they might both be adequate. And that's the courts we're looking at. Fifth Circuit took a similar approach, Jones versus Tulane. The Delaware District Court in Delaware, some of these cases never made it in particular to circuit court levels. But again, students' contract and unjust enrichment claims survive in Nineveh, which is a Delaware case. A D.C. Circuit we mentioned earlier, Schaefer versus George Washington University, federal case, a circuit court case, a COVID-19 case. Again, affirming that university preach express contract promising, here, express notice, promising in-person education, adequately alleged breach of implied contract as well. So again, you got both express and implied recognized, and the court was in the same ballpark as these other cases. We've talked about unjust enrichment. One thing we did not talk about, which has been made in some of these cases, is a conversion claim. So the court in D.C. and other courts have dismissed conversion claim. I presume what plaintiffs were doing there is they wanted to throw in the whole meat market, hoping that something would work just in case the courts said, no, we're not going to recognize anything outside of an express contract. So let's put in there conversion. Some bright young associate came up with that idea, and of course said, there's no possessory interest in a specific identifiable fund of money. And consumer protection claims have had, we mentioned earlier, that some of these cases have been brought under various state uniform acts. And the general decision on that has been that the courts have not outright dismissed them, but usually permit some development of the record. So in this case, this DC case, the circuit court reversed and remanded for dismissal. So I would say probably 75% of the courts, 80% of the courts have not recognized unfair consumer protection kind of claims. And the reason is that most states that have those statutes provide for attorney's fees and potentially punitive damages and other stuff that judges don't want to see universities have to deal with. That's just my kind of offhand, off the wall kind of view as to what the judges might be thinking when they made those decisions. So, one interesting little tidbit: Ross versus Penn State, which was one of the cases that started the ball rolling on all of this. A case that I tried, and I tried it before a judge that I had clerked for as well. So I always felt that he and other ex-law clerks have told me the same thing. I usually have to work twice as hard to get half the result from the judges they worked for. So that's my story, and I'm not changing it. So thank you very much for listening in. It's been interesting discussing this evocative and continuously changing area of the law. I'm sure we'll see a lot more movement in this area in the future. So thank you very much for being with us. Take care, be well, stay healthy. Bye now.